I've certainly put on my website and in blogs a description of the contingent fee system. It has been called the poor man's key to the courthouse. And why is that? Because the so-called poor man isn't putting up money for an hourly fee. But why is personal injury conducive to a contingent fee? And it's because of a Latin term, res, R-E-S. What does that mean? It means a thing or an object. And in personal injury, obviously, at the end of the day, you hope to have a settlement or an award or verdict. That will be the thing or the object from which the percentage fee will be taken. So as you can see, because there's a pile of money at the end of the case, it lends itself to the sort of fee structure of a contingent fee. And it's so much better than having a client pay upfront money. And there are several reasons for that. Number one, the client may not have the money. In fact, typically, many of us will not have the money to put in to develop the case. And obviously, I've often written and spoken about experts and how expensive they can be. So it's a fact of life, however, that you need experts in the development of your case. So it can be a very expensive process to develop a case. And given the fact that many people don't have this available pile of money, it makes it all the harder, almost impossible, if they were to have to finance their case and, in addition, pay a lawyer for his or her time. In selecting a lawyer, I think you should ask explicitly, am I expected to come up with the out-of-pocket expenses as they are being incurred? And if the answer is yes, that would, for me as a would-be client, be a very concerning feature. In my firm, we don't do it that way. We advance the money for costs in the litigation, and we don't want the client to have a sleepless night, to say, gee, I put in X thousands of dollars, and what if this case doesn't work out? That leads to my next point, which is if the case is not successful, and thankfully that has occurred very seldom in 35 years, but if the case is not successful, the lawyer is not obligated, and indeed puts it in the contingent fee agreement now, that the client will not be responsible for those expenses. Why do I structure my fee arrangement that way? I do it because for me it's a business, and it's a business expense. And if, unfortunately, very unfortunately, the case doesn't result in a successful recovery, I'll just chalk it up as an unfortunate event in the life of my business, and it won't have the same catastrophic effect that it would have on somebody who didn't recover money and then is obligated above and beyond to pay for those out-of-pocket expenses. So to summarize, the res, the thing or object, lends itself to a good fee system known as the contingent fee system. And even with a contingent fee, please be assured that your lawyer will not ask you for expenses as they are becoming due, because it will put a financial strain on you as well as an emotional strain. Thank you.